RSA offers business-driven security solutions that provide organizations with a unified approach to managing digital risk and designed to effectively detect and respond to advanced attacks, manage user access control, and reduce business risk, fraud, and cybercrime. For a limited time, get mobile multi-factor authentication from RSA Secure ID Access for free to help secure your remote or dynamic workforce long-term. Leverage push notification, biometric, and one-time password authenticators to secure access to your cloud applications, on-premises systems, legacy systems, privileged accounts, and more at no cost for 6 months. For more information, visit securityweekly.com/RSA Security.
Welcome back to Security and Compliance Weekly, episode 37. We've been getting to know our newest co-host, John Snyder, and we've been having, so far, a very fascinating discussion on the law and how the law applies to security and compliance. We want to jump back into the conversation, but I do have a few announcements first. Security Weekly is an official media partner for Virtual Black Hat 2020, which is next week, guys. We should be in Vegas next week, and we're not. To register and save $200, you can visit securityweekly.com/summercamp2020. Look for the red registration bar, and in that bar you can see the discount code, which is 20SECWEEKBH. And aside from that, aside from Virtual Black Hat, Security Weekly is also running our own conference micro interviews, which we're calling Security Weekly Virtual Hacker Summer Camp. This is all happening next week. You can go to our website, the Summer Camp 2020 webpage, and look for options for pricing and also availability if you want to sign up for an interview slot. I think that there's a few still left. I know our operations manager, has been working feverishly to fill all the slots and sort it all out. So go there and check it out. Sign up and get the discount, or sign up for an interview. Also, our next webcast coming up on August 13th, we're going to teach you how to be safe in terms of your internet self. You can register for this or any of our upcoming webcasts or virtual trainings by visiting securityweekly.com/webcasts. And of course, you can always watch previously recorded webcasts or trainings by visiting securityweekly.com/on-demand. All right, enough of that. I want to get back to the discussion. We were just getting ready to hear John explain how to fix everything in terms of the legal system with regard to, I think, society in general, but security and compliance. Before you jump into that, John, I wanted to ask of you, sort of a question that we ask a lot of our technical interviewees, and I think it's appropriate here. Let's not assume that our audience is as well versed in the law, in terms and strategies and nuances and aspects of the law as you understand them. As best as you can, I was hoping you could sort of take a step back and just give us, you were sort of talking about it a little bit in the first segment, but how does the law work? How does the legal system work? How did it come about? And what is it that's not keeping up and needs to change? So hopefully you can weave it into your answer. Let me prime the pump by asking you the question I always ask lawyers when I meet them, and hopefully this will help you.
He's not a divorce lawyer.
For your response.
Jeff. He's not a divorce lawyer.
It's okay. No, my question is simply this: what is a tort? Go.
A tort is a civil wrong, and basically it's a when you get injured, or if your physical integrity or your property interests are violated, and you want to sue for money damages, that's a civil tort.
It's a small fruit-covered pastry. Jesus, some people.
Well, that's the more appealing tort.
It is. I asked that question because my brother, who was a lawyer, when he first started going to law school, he brought home this textbook that was probably 3 inches thick, and it was a book on torts. I guess it's everybody's 101 tort law textbook. And the very first
Yeah,
sentence of the very first page is and I'm paraphrasing because it's been many years, nobody's really ever come up with a good definition of a tort. I'm like, but you're going to talk about it for a 3-inch thick book. That is the
Hey,
law
Jeff,
as I
Jeff,
perceive it.
Can you define secure?
Go ahead. Sorry.
I can, but we're talking to John right now.
No, you can't. One thing. Second
Yes, I
thing,
can.
you might be able to define it, but your definition will not meet what other people define it as. Can you define
agree.
compliant? Can you define? There's a lot of things. What's a pen test? There's a lot of things that we can try to define, but we can all agree that we know what they are, but we can't come up with a definition of them. So it's in our industry as well, my friend.
Fair enough. Which is why I double down on thinking it's important to at least hear how John defines the terminology. And
All right, I'll shut up.
So that we have a basis from which to engage in conversation. And yes, I can define secure and security.
Well, you're wrong.
So,
but that's okay.
For the benefit of the audience, typically the first courses you take in law school, you take contracts, you take torts, which is lawsuits not relating to contracts, you take criminal, you take civil procedure, and you take property, and that's basically the fundamentals of law. Very, very few law schools teach cyber in any concerted way. Some are bringing on a class or two, but it's interesting because we devote 1/5 of our first year to real estate, right? And I would take the position that cyber is a bigger market than real estate even now today. So legal education needs to be updated, but more important, if you think about it, and this is, hopefully this will resonate with some of our listeners. You're going to need to give me about 60 seconds for this answer. But our systems of doing things, our institutions, are generally, and this is the case with courts, but it's the case with everything, were created in the 40s and 50s, 30s, 40s, and 50s, the New Deal, World War II era, to solve problems that as they existed in the 30s, 40s, and 50s. So, for example, our court system, the rules and procedures are all set up to be optimized to solve problems of 1938, which was the year that the Federal Rules of Civil Procedure were adopted. We are in a world in 2020 that looks nothing like the world of 1938. Nothing like it. And therefore, the policies and procedures and ways that we solve problems are totally different. But our institutional structures have not caught up. And as a matter of fact, because of the nature of bureaucracy, the type of people who get to the top of a bureaucracy are not creative people. They are people that administer already existing systems. They don't think of new systems. And therefore, I'll give an example like, John Roberts, Chief Justice of the United States Supreme Court. He would be a wonderful university president in good times. He's a wonderful Chief Justice in good times. But he is not the kind of person who's going to sit down and say, okay, we're going to reconceptualize how we do jurisprudence. And so if I had to identify a core problem that faces us today, it is the fact that our institutions are no longer working, and the people running them don't realize it, won't admit it, or don't have the capability to do anything about it. And that's our problem.
All right. So now, did you answer Josh's question, or
No, he really didn't. He answered the why it's
answered my
bad, but
question.
not the what can be done, if that makes sense.
All right. So Josh, what can be done about it?
What can be done? We got to perceive our problems correctly. The problem we have in law, the reason that our courts don't work right, is because we don't have procedures for dealing with the most expensive part of litigation today, which is ediscovery, right? And so what the courts need to do is they need to take responsibility for executing on their core mission, which is to provide speedy and expensive justice. That is not currently happening. And as far as I'm concerned, it's the responsibility of the judges to make sure that happens. If the judges don't make sure that happens, they have failed. And the only way to do that is for the courts to actually take ownership of the technology infrastructure so that they can control the costs and they can actually solve the problem. See, right now in litigation, judges basically say, I don't want to be bothered with e-discovery. The parties, you guys figure it out. Don't bother me with it. And of course, parties go spend millions of dollars on e-discovery because they can't work out a way to do it efficiently. So that's how you solve the problem. Is you build procedures that match the problem.
So, John, I got to say two things. One is that when you said, speedy, inexpensive justice, I heard that for just a second as speedy and expensive justice, and it made me laugh. I realized you said inexpensive, but I heard it as and expensive, speedy, and I was like, that should not be a core mission.
In Rule 1 of the Federal Rules of Civil Procedure, where it says purpose, everybody can look it up, FRCP 1, and it says the purpose of these rules is to provide the speedy, just, inexpensive resolution of all disputes.
No, I understand that, but I heard and expensive, and it made me laugh.
Yeah.
Well, it's the paradigm. It's the triangle of good, cheap, fast, pick two.
Right. And here's the kicker. From what I'm hearing from you, John, what I'm hearing from you is that you want to reform the justice system just as much as there's quite a few people out there saying we should reform the police. You're saying let's reform the judiciary as well.
Yes. As a matter of fact, I told you the Federal Rules of Civil Procedure are basically the blueprint for how we do justice in America and frankly around the world, because a lot of countries have copied us. We need to rebuild our civil justice system from the ground up, and it needs to be built on a foundation of technology that is optimized for handling very, very large amounts of disparate, unstructured data. By the way, the same problem and the same solution apply to police. Police have enormous amounts of data that is there to be, looked at and mined and learned from. They aren't capturing any of it. Look at body cams, right? It's about 1 gig an hour of video data. And are police departments doing anything with that? No. So, as I said, institution after institution is having the same problem, which is it doesn't have an effective way of making sense of enormous amounts of data. And that's actually the problem that Agnes Intelligence is solved, is that problem.
So you're saying that there's a technological solution to the cultural problem of a court system, a judiciary that has no idea what technology is, much less how to use it.
There is a technological solution. If you let me have 1 year as Chief Justice, I will fix everything.
All right, everybody, you heard it here first.
the people and the power and the technology on the same page. And so I've done the hard part. I've invented the technology.
Okay, valid. So remember, everybody, you heard it here first. When John gets to be Chief Justice, everything will be fixed in a year.
Oh, I thought it was a year from today.
No. Come on, man. Give him Chief Justice first, all right?
What we can do in a year. In a year, we can implement the technology. We can implement new rules. Now, of course, there will be a phase-in period, and some of the old-timers are just going to not want to do it. So it'll take a decade to get everybody on board. But
You can set the roadmap in a
we
year.
got to start now, because look at what happened. Look at what happens to a civilization when people stop looking at the courts as a force for equality and individual rights. Look at what's happening in Portland. They're laying siege to a federal court. I mean, that is what happens when courts stop serving the public.
Okay, so let's stop there for a second, because we want to steer clear of politics to a certain extent, even though we're brushing perilously close. But your point about courts are not seen as the source, the fount, or the protector, the guardian of justice, equality in the American way, apple pie, motherhood, baseball, whatever. And if that's the case, then we need to fix the courts. The big problem you're stating, as I hear you, is that the courts are not up to speed technologically. Sorry, wrong way. They're not up to internet speed in terms of handling data. They're not up to internet speed in terms of processing data. They're not up to internet speed in terms of using data. And you're stating that that's a primary problem with the court system today. And that there are solutions, but these are technological solutions, as well as some cultural solutions, in that we're going to have to attrit current judge and lawyers to get to ones that are actually technology literate and useful, shall we say. Have I basically summarized?
Yeah, I'm not sure that we're going to be able to do that with the federal judiciary the way that they're staffed. I think we may have to create a parallel court system that works on modern technology, and basically we may have to treat the federal courts as a competitor and just beat them. I don't know. I don't know what the answer is going to be. I'd love to do it through the federal courts.
The Bitcoin of justice. Sorry, I couldn't resist.
Yeah, I mean, look, I love the blockchain of justice.
The blockchain of justice. I love it. Yeah, there we go.
I have reverence for the federal courts and what they represent and what they've done, which is why it's so painful to see them no longer able to do their job.
It's hard not to trip over the politics in terms of a legal discussion, because I think part of the problem that John's describing is the fact that the justice system, which is supposed to be a co-equal branch of the government, has gotten extremely political. Maybe I'm a little bit tainted, but I don't think of the judicial system as having much to do with justice at all. It's based on my limited understanding, and I'm not a lawyer, the fact that things don't go to court. And I think, John, you had said on an earlier episode that, or maybe it was just us talking, you would love to get in the courtroom because you'd always win. But so much of the legal system is sitting down and looking at what the norms are based on established precedents of, okay, you committed this kind of crime or you committed this kind of injury. Historically, you get X number of years and X number of dollars fine. We're gonna go with that and tweak it a little bit. And so and so many of the law movies and shows that I see, it's all about the bargaining and the positioning and coming up with the best deal rather than going into the court and settling. What are the facts? Who did who to what? Can you prove it? Do you have witnesses? And so on and so forth. So to me, it's all political. My question to you is, some of the traditions and the classical concepts that the judicial system was built on historically, do they play in today's cyber electronic digitized technological world? For example, the idea of habeas corpus. Is there a technology equivalent to the concept of habeas corpus?
Explain to me how you a little more about that, because obviously habeas corpus is the federal constitutional right to come before a federal court and say that I'm being unconstitutionally detained.
I guess I'm going, and maybe my understanding of the origins and the terminology is wrong, and you correct me. But habeas corpus in Latin is
show me the body.
Show me the body. You have to have evidence. That you have to have, something to point to and say a wrong has been committed. How does that play in the technological world? I'm thinking of all the different law movies that I've ever seen. The idea of the right to face your accuser. How does that work when the accuser is an AI system that sorted a whole bunch of data and determined that there's something wrong going on? I mean, I'm not looking for right answers. I'm looking for a little bit of brainstorming and maybe some visionary thoughts of what does this all look like in the future?
So I'll answer it just sort of by talking about how the art of lawyering has changed.
Okay.
If you go back to the 40s and 50s, Perry Mason and Atticus Finch, it was the art of lawyering was the art of cross-examination. Right, you get the witness on the stand and you break them down and you get them to admit they were lying or whatever.
Perry Mason, it's all
exactly.
the Perry Mason thing. Yep,
and that was seen as that's what lawyers do. That was in an age before we had very many documents. We didn't even the Xerox machine, the copy machine, didn't even come into being popular until late 50s, early 60s. So. Right. If you go back to the 1930s, 1940s, you're dealing with lawsuits that involve maybe a box of documents, of originals. I mean, very few documents. So if you wanted to find out what happened, you had to cross-examine people. That's how you found out. Well, today everybody does everything over email, right? And so there's much, much more evidence. And so instead of cross-examination being sort of the heart of lawyering, now it's dealing with the data and trying to figure out, the truth within this pile of 10 million items that are junk, right? And so the craft of lawyering has changed as the data sphere has changed.
Mm-hmm. Interesting. Josh, Scott, other questions?
We've been talking about where law is going. We've been talking about where the judiciary is going. We've been talking about making the judiciary up to, what do we call it, internet speed? And it's interesting because technology, for example, in the Discord, Lothwin, who earlier we were talking about interesting pants and kilts and pockets, is now talking about how you cannot compel someone to use fingers, thumbs, facial recognition, or any other biometric feature to unlock electronic devices. Lothwin, rock and roll. That's fascinating. So they are trying to stay up to speed technologically by determining through precedent where the various different types of authentication authorization are. This is under the Fourth and Fifth Amendments. And so, it's interesting. Sorry, I'm sort of leading up to this. I apologize. It's almost my conception that the court system is using precedent and interpretation much as, Orthodox Jews interpret work on the Sabbath, on Shabbat, and Protestants on the Sabbath. And it's fascinating how nitpicky they get. But I mean, this has always happened this way, right, John? But it's just now that we're seeing it happen in such much faster time that they don't have time to socialize these things with people, and so they keep popping out as things happen. Am I sorry? Did that make sense?
It makes perfect sense, and I'll give you a good example. Our rules of e-discovery are kind of based upon a trilogy of cases written in the mid-2000s called Zubalake, Zubalake. And, they talk about the considerations that should be taken into account when deciding whether one party to a lawsuit should have to bear the expense of producing all this data to the other side. And then there's been some rules have been put in, but at the end of the day, the rules just say do what's reasonable. So
Define reasonable,
at the end
please.
of the day, you always get back to a question of what's reasonable. And the problem is, what might have been unreasonable in 2004 may not be unreasonable today. And
Because of the increasing technological
courts
capabilities.
are not set up to deal with conditions that are changing every 6 months, right? Because it takes longer than that just to get a case decided, right?
Yeah.
And so you're always playing 5 years behind, and that's going to be the problem with any. I mean, sure, you'll get the odd case. You get the case where the U.S. government demands that Apple put a backdoor, and that'll get litigated. But that's one data point. Typically what you have is you got hundreds of cases, and the courts kind of look at how other courts have dealt with things, and a rule emerges. And just as you're saying, Josh, with the pace of technology and the speed with which the conditions on the ground are changing, I question whether the courts are institutionally competent to make rules in this area.
Okay. I know we've got to pretty much wrap up, Jeff. I'll hand it back to you in a second, but I really would like to hear from our viewers and listeners, either in YouTube comments, on the Discord. I don't know any other locations. I'm sure there's other locations they can comment, how they could see the court system changing in order to catch up to technology, in order to speed up their responses to technology, in order to even get ahead of technology. And I'd love to see what people think. I'm fascinated by this topic. Jeff, I'm going to hand it to you.
Here's one. How about we treat civil disputes with the same urgency we treat a broken leg? You break your leg, it doesn't take the doctors 5 years to fix it. It is absolutely possible to get the documents collected, get the people in a room, and in 30 days have a case resolved. It's technologically feasible. There's nothing stopping it other than the fact that, frankly, law firms have convinced the world that lawsuits should take 5 years, because how do you bill a lot of hours? Well, have a case go on for 5 years. That's a good start. And so a lot of these rules are written for the benefit of lawyers to rip off their clients. And, and trust me, I mean, I'm a lawyer. I have perfect, professional self-interest, but I got to tell the truth. And I got to say, there's no reason that a case should have to go on for 5 years. It should be done in 30 days. And, it should cost it should cost 5 figures.
Interesting.
And that's totally possible.
If somebody wanted to reach out to you and they say, hey, I've got this issue, either in being sued, or I need to deal with a vulnerability disclosure, or anything information security hacker related, how would they find you?
Oh, you can find me on Twitter, Hackers Lawyer, Hackers Lawyer. You can also reach out to me directly by email, John, John, at jhs.nyc. John at jhs.nyc. And, we love hackers. We love the hacker community. We like to get to know people. So feel free to drop me a line, and we'll discuss more.
It's been a fascinating discussion. I do find it mildly humorous. This is the way my mind works, that to a largely hacker audience, you spelled out hacker and not lawyer. Just a thought. Final question, and then we'll wrap up. And I think I had asked this question maybe the first time episode you were on, but digging way back, because I have my list of favorite lawyer movies. What's your top 3 list of lawyer movies, not TV shows, movies, all time?
Number 1's My Cousin Vinny, just because every trial lawyer knows it. Because every trial lawyer has tried their first case and can relate to it. The best line from that movie is when Joe Pesci goes to give his opening statement. The prosecution first gives theirs, and Joe Pesci gets up and he says, "Everything that guy just said is bullshit. Thank you."
Thank you.
the judge says the jury shall disregard everything in the opening statement except for the words "thank you." So it's a brilliant one. Inherit the Wind is a great one, and Born on the 4th of July has a great courtroom scene. But I gotta say, like, among lawyers, the one that we always watch, we love My Cousin Vinny. That's the best.
Right. My top 3 are Absence of Malice, A Few Good Men, and Justice for All. And surprising that neither of us pick any of the Grisham movies or books. But
wait, you picked a Metallica? You picked a Metallica CD?
I think the Metallica CD was named after the movie. I'll stake a drink on that, or a cigar. But anyway, fascinating discussion, and as we proceed forward with the show, we now have the benefit of having legal counsel on hand in case we ever get to any disputes. We can at least get the legal perspective on the things that we talk about. So, John, welcome to the show. Valuable asset that we've added, I believe, and I think that will play out. And let us know what we can do to help you get your nomination to the Supreme Court moving along. Other than that, reach out with comments, YouTube, Twitter, Discord, if you happen to see us, but stay socially distant and throw our questions on a crumpled up piece of paper or something. Next week, just as a quick announcement, we are going to be on hiatus as it is Tacker Virtual Summer. We're not in Vegas Black Hat Week, whatever we're calling it, and we'll be back the following week broadcasting live. So stay cool, stay safe, stay distant, wear a mask, and we'll see you in a couple weeks.